Good day. Our topic for today is Rule 120 on judgment. What do we mean by judgment? Judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged and the imposition on him of the proper penalty and civil liability, if any. In other words, after all the proceeding wherein the prosecution proves the case, they prove all the elements of the crime, as well as the identity of the accused to be the perpetrator of the crime, as well as the defense of the accused. The court shall adjudicate as to the outcome of the proceeding, and we call that as judgment. And how does a judge prepare a judgment? It must be written in the official language. So, in our jurisdiction, our official language is the English language, personally and directly prepared by the judge and signed by him, and shall contain clearly and distinctly a statement of the facts and the law upon which it is based. In other words, aside from the fact that it is written in the English language, it is mandated, the rules mandates the judge to personally and directly prepare the judgment. And of course, he has to sign on it. If the judgment contains more than one page, he also has to affix his signature, or in my case, I do the initial on each of every page and affix my signature on the last page. What shall the judge needs to state in the judgment? He will have a statement on the facts based on what is being presented by each of the litigants. Then, what was the verdict? What was the decision? Because you have to remember that the prosecution and the defense have conflicting arguments. The prosecution alleges, proves the case, the defense refutes. So who among these two contending parties are saying the truth? And if the prosecution was able to prove all the elements of the crime, hence impose a judgment of conviction upon the accused. Aside from the facts as established during the trial, what was the law applied to come up with the verdict of acquittal? Or why would the court would say that the accused is guilty? So the court shall state therein the law as well to which his decision was based. Remember when we had a topic on jurisdiction, that you have their requisites wherein the court has acquired jurisdiction. So the jurisdictional requirements before a judgment may be rendered in a criminal case are as follows. Remember that each of these three has to be present so that we can say that the court validly exercised jurisdiction. The court must be able to obtain jurisdiction over the subject matter basis the allegations in the information or the complaint, and as provided for under the law. Okay, it is conferred by law. Jurisdiction over the territory, meaning to say whether the court has jurisdiction over the territory to which the elements of the crime were committed, and that whether or not the court was able to validly acquire jurisdiction over the person of the accused. Take note that the three has to be present because absence of one shall be a ground to nullify the entire proceeding. It shall be considered as void ab initio. Okay, to reiterate, what are the contents of a judgment? the legal qualification of the offense constituted by the acts committed by the accused, and the aggravating or mitigating circumstances which attended its commission. In other words, it must say, for example, if you have there a crime of murder, the court has to state the particular provision of the law that defines murder. Of course, why would it be murder? The court has to specify as well the aggravating circumstances, as well as the mitigating circumstances, if any, that attended its commission. You have to remember that in the information, what was stated is only, aside from the acts committed by the accused, you have there the aggravating. Take note, mitigating circumstance was not mentioned or is not or shall not be mentioned in the information. But in the judgment itself, since these mitigating circumstances are within the responsibility on the part of the accused to prove them during trial, so when the judge prepares his judgment, he has to state as well the mitigating circumstances as proved during trial. Now, if there are more than one accused in a particular case, the court shall likewise specify what was the degree of participation of the accused to the offense. Was he a principal? Was he an accomplice? Or just an accessory after the fact? Why is that important? Because the penalty to be imposed upon the accused, his participation, actual participation in the commission of the crime, also is very substantial or determinative of the proper penalty to be imposed upon him. And the court shall likewise specify and state the civil liability or damages, if any, unless the enforcement of the civil liability is through a separate civil action or the private complainant has waived its claim. So all of this has to be stated in the judgment of the court. Now, take note that if the verdict of the court is for acquittal, the court shall likewise state the reason why the verdict was for acquittal and what was the degree, if ever, or what kind of acquittal was it, so that the court can properly impose civil liability, if any. Now, take note that if the evidence for the prosecution absolutely failed to prove the guilt of the accused, or merely failed to prove his guilt beyond a reasonable doubt, in either case, the judgment shall determine if the act or omission from which the civil liability might arise did not exist. Meaning to say, if the reason was that it failed to prove the guilt of the accused, or absolutely failed to prove its guilt, it must follow that if this is the reason, the same shall be the basis as well to award civil liability. For example, absolutely failed to prove the guilt of the accused, like the prosecution failed to prove the identity of the accused to be the perpetrator of the crime. So probably there could be mistaken identity. So in other words, the accused could never be criminally liable because there was mistaken identity. In other words, you could not also make him civilly liable because there is no basis to award civil liability or damages because the prosecution absolutely failed to prove the guilt of the accused. On the other hand, if it merely failed to prove his guilt beyond a reasonable doubt, meaning to say, the prosecution was able to establish, let's say, majority of the elements of the crime. However, there is that 1%, meaning to say 99%, the court, the prosecution was able to prove his guilt, but there is that 1% gray area wherein there is that doubt whether, and that doubt would actually resolves in the acquittal of the accused. To illustrate, if the prosecution was able to prove that indeed there was receipt by the accused of the money from the private complainant, only that there is actually doubt as to the nature of the transaction between them. Maybe it could be a loan or maybe, or whatever obligation is that. The prosecution failed to prove with certainty that kind of transaction. And with that, that would actually negate deceit, which is one of the elements of staffa. So in other words, the prosecution was only able to prove the existence of that receipt by the accused of the money from the private complainant. However, it failed to prove that the accused, when it received the money from the private complainant, it acted with deceit. So in other words, the accused would still be acquitted because the prosecution failed to prove the guilt of the accused beyond reasonable doubt, but it can make the accused civilly liable. In other words, while the accused was acquitted because his guilt was not proved beyond reasonable doubt, the court can still make him civilly liable. And take note that the verdict of acquittal is actually immediately final. Okay, immediately final. Meaning to say, can that acquittal be subject of appeal? General rule, it is not subject to appeal. Okay, the state cannot appeal a verdict of acquittal on the accused. The only exception is that you can appeal as far as the civil liability, if any. Okay, but as to the criminal aspect, you cannot appeal. To do so would violate the right of the accused against double jeopardy. You can have more on it when we reach appeal. That's why it is immediately final. Now, how about if the judgment is for conviction? Then, the accused or any aggrieved party for that matter can file an appeal. Why? Because a verdict of conviction is not immediately executory. You have there the 15-day, the crucial 15-day period that needs to lapse prior to the finality of the conviction of the accused. You have their judgment for 2 or more offenses. What does it mean? In Section 3, it provides, when 2 or more offenses are charged in a single complaint or information, but the accused fails to object to it before trial, the court may convict him of as many offenses as are charged and proved. and impose on him the penalty for each offense, setting out separately the findings of fact and law in each offense. In other words, the failure on the part of the accused to quash the information for being duplicitous, it actually can be considered as a waiver on his part when he entered his plea. And Section 3 allows the court to convict him of as many offenses charged there in the information for as long as it is also proven during trial. Okay, all the court needs to do is to support, state the facts to each of the crime charge and the law applicable on each, and give him the proper verdict. In Section 4, it is a situation wherein there is variance between the offense charge in the complaint or information and that proved. And the offense as charged is included in or necessarily includes the offense proved. The court shall be convicted of the offense proved, which is included in the offense charge, or the offense charge, which is included in the offense proved. You call that as the variance doctrine. Would it violate the right of the accused to know the nature and cause of the accusation against him? No, because the offense proved was necessarily included in the offense charge, so he was informed. Same thing that he can also be convicted of the offense charge, which is included in the offense proved. So that is the variance doctrine. When an offense includes or is included in another. So in Section 5, it provides an offense charge necessarily includes the offense proved when some of the essential elements or ingredients of the former, as alleged in the complaint or information, constitute the latter. In other words, the offense charge, its elements are actually included in the offense proved. And an offense charge is necessarily included in the offense proved when the essential ingredients of the former constitute or form part of those constituting the latter, so vice versa. So let's have an illustration to apply the provision of the law, of the rules. Thus, if the accused is charged with murder, okay, he was charged with murder, but it was homicide that was proven. In other words, the elements of homicide was proven, which are also elements as charged in the information for murder. So if that is the case, the accused shall be convicted of homicide, the offense proved. Now, homicide is included in the offense charge, which is murder. Now, you might be asking, what's the difference between the two? The presence of the qualifying circumstance, which distinguishes murder from homicide. Homicide there is the generic killing. So, in other words, the elements, the essential elements are actually the same, except that in murder, there is that allegation of any of the qualifying circumstances that would change the nature of the killing by the accused. Now, since the prosecution failed to prove the qualifying, then the accused can only be made liable for homicide, which is the offense proved in the information for murder. Also, if a person is accused of homicide, but it was murder that was proven, The accused shall be convicted of homicide, the offense charge. Why? Remember that the offense charge was only homicide. This presupposes that the prosecution did not state any qualifying circumstances in the information. Even if the prosecution was able to prove murder, because during trial, it was able to prove a qualifying circumstance. Remember that in the earlier discussions, you've learned that all these aggravating circumstances has to be stated in the information and proven during trial. Now, if it was not stated in the information, even if proven during trial, that cannot be taken against the accused. Hence, under this circumstance, the accused can only be made guilty for homicide, which is the offense charge. He shall not be convicted of murder, the offense proved, since murder was not the offense charge. So if you notice here, murder carries with it a higher penalty than homicide. It is the lesser penalty, lesser charge to which is the offense charge to which the accused can be made liable, but not on murder, which is the offense proved, because it is not included in the offense charge. Another illustration. A is charged with rape by sexual assault, but what was proven was acts of lasciviousness. He can be convicted of the latter. So, he can only be convicted of acts of lasciviousness. Now, are the two have almost the same or has the same elements? The answer is yes, because it could be that the rape by sexual assault was committed by inserting the finger into the genital of the private complainant. Now, it could be possible that the accused cannot be made liable for rape by sexual assault if the prosecution failed to prove the only element that distinguishes rape from acts of lasciviousness, which is intent to lie. So in other words, it could be possible that there is no actual rape that took place by inserting the finger, but then it could also constitute the crime of acts of lasciviousness. Since the acts of lasciviousness was the offense proved and its elements are included in the offense charge of rape by sexual assault, hence he can be made liable only for acts of lasciviousness. However, if A is accused of acts of lasciviousness, he cannot be convicted of rape, the offense proved. Just like earlier, the offense charge was homicide. He cannot be made liable for murder because during trial, we're able to prove a qualifying circumstance. Now, that would be an outright violation of the right to due process and his right to be informed of the nature and cause of the accusation against him. So if you notice on the two illustrations that we have, this variance doctrine is actually a manifestation on that provision which says that penal laws are liberally construed in favor of the accused. So if you notice, the illustration end point is that at the end of the day, what is favorable to the accused prevails. Now, The variance that we have earlier is on the charge, offense charge and the offense proved. Here, in this case, what we had is variance in the mode of commission, meaning to say there is variance on how the act was committed. The victim testified that he was aroused from sleep with the male organ of the accused inserted in her mouth. But the information alleges force and intimidation as the mode of commission. Meaning to say there is variance, there is discrepancy as to how it was committed, how rape was committed. In People versus Abilio, this variance is not fatal to the conviction of the accused for rape by sexual assault. The variance in the mode of commission of the offense is binding upon the accused if he fails to object. The variance is not a bar to his conviction of the crime charge. Okay, for rape by sexual assault. The information is clear. It was committed through the insertion of the penis of the accused. Now, it would still be rape. So, if the same was committed through force and intimidation, and it's not, it would not even be, it's actually be higher. It entails a higher penalty because the force and intimidation there could be the mode of committing the traditional rape, which carries with it a higher penalty than rape by sexual assault. So, variance in the mode of commission, it's not fatal. Okay, let us say that the court is done preparing the decision or the judgment. So what shall the court do next? The court has to promulgate the judgment. In Section 6, it provides the judgment is promulgated by reading it in the presence of the accused and any judge of the court in which it was rendered. So usually, who will read the judgment when the same is promulgated? It's the court interpreter. However, if the conviction is for a light offense, the judgment may be pronounced in the presence of his counsel or representative. So remember that while the presence of the accused is mandatory in 3 instances, arraignment, promulgation, as well as when mandated by the court for purposes of identification. So in the promulgation, as an exception, the accused need not be present if he is charged for a light offense. So his presence is not required if it is for a conviction for a light offense. So even if he is not around, the promulgation shall proceed. The judgment may be pronounced in the presence of his counsel or representative. When the judge is absent or outside the province or city, the judgment may be promulgated by the clerk of court. Now, take note, it talks about conviction. Now, how about if it is acquittal? With more reason. Okay? With more reason. Acquittal for a light offense. Now, how about if it is not? Sometimes, the court will just proceed even if the accused is not around for as long as he was duly notified of the promulgation of judgment and despite notice, he failed to appear. The court can proceed. Okay, the court can proceed. As to consequence, there would be significance when the same is for conviction or for acquittal, which we will discuss later. Now, if the accused is confined or detained in another province or city, in other words, he might have a case here in Cebu and he was arrested on that case here, so he was detained here. And then it would also appear that prior to his arrest here in Cebu, he actually committed another case in another province. So since the Court of Cebu took jurisdiction first over his person, then he shall be detained here while the case in another province, for example, or city shall also proceed. Only that he is detained here in Cebu. If the accused is confined or detained in another province or city, the judgment may be promulgated by the executive judge of the regional trial court having jurisdiction over the place of confinement or detention upon request of the court which rendered the judgment. So in other words, the court will coordinate with the executive judge over the place for example, if that case is in Bohol, so the Bohol court to which that other case of the accused is pending can request and coordinate with the executive judge in the RTC here in Cebu who has jurisdiction over the place of his confinement or detention. So the court promulgating the judgment shall have authority to accept the notice of appeal and to approve bail bond pending appeal, provided that if the decision of the trial court convicting the accused change the nature of the offense from non-bailable to bailable, the application for bail can only be filed and resolved by the appellate court. In other words, if he is charged for murder there in Bohol, and he was also charged for another murder case here in Cebu, and he is detained here in Cebu because the Cebu court was able to obtain jurisdiction over his person first than that the one in Bohol. So the Bohol court will coordinate with the EJ and the RTC here in Cebu, who has jurisdiction of the place of his confinement or detention. Now, if the judgment original charge was murder, but he was only convicted for homicide, wherein homicide is not reclusion perpetua. It does not carry with it the penalty of reclusion perpetua. He can file bail pending appeal. Where will he file it? In the RTC who promulgated the judgment? No, but in the appellate court. When would this be possible? If the charge of the accused change its nature from non-bailable to bailable. When shall be the promulgation of the judgment? Administrative matter number 15-06-10 or SC or the continuous trial rule. The court shall announce in open court and include in the order submitting the case for decision the date of promulgation of its decision, which shall not be more than 90 calendar days from the date the case is submitted for decision. In other words, in the order of the court admitting, because the last prior to promulgation, you have there formal offer of exhibits by the defense, and let's say there was no rebuttal or so rebuttal, so that order, in that same order, the court has to state the date already, incorporate the date already as to when shall be the promulgation of judgment. Under the revised guidelines for continuous trial in criminal cases, the same shall be done not more than 90 calendar days from the date the case is submitted for decision. Except, of course, when the case is covered by special rule and other laws which provide for a shorter period. Like, if the charge is for violation under RA 9165, this same shall be done within a period of 45 days. And if it is governed by the rules on summary procedure, it shall be done not more than 30 days. Okay? From the date the case is submitted for decision. How do we promulgate? The proper clerk of court shall give notice to the accused personally or through his bandsman or warden and counsel, requiring him to be present at the promulgation of the decision. If the accused was tried in absentia because he jumped bail or escaped from prison, the notice to him shall be served at his last known address. Okay, even if he already jumped bail, the court actually did a trial in absentia, he would still be notified. Where will it be sent? At his last known address as appearing in the record. In case the accused fails to appear at the scheduled date of promulgation of judgment despite notice, the promulgation shall be made by recording the judgment in the criminal docket and serving him a copy thereof, where? At his last known address or through his counsel. And that is fine. So let's proceed with the consequence, because earlier I've told you that whether it is for conviction or acquittal and the accused was not present at the time of promulgation, the consequences are different. If the judgment is for conviction and the failure of the accused to appear was without justifiable cause, he shall lose the remedies available in this rule against the judgment, and the court shall order his arrest. Now, of course, say, what is that exception? If for a light offense. Okay? Within 15 days from promulgation of judgment, however, the accused may surrender and file a motion for leave of court to avail of these remedies. Okay? What are the remedies that the accused might lose because of his non-appearance? Motion for new trial, reconsideration, and even appeal. So he will lose it. And on that very day, is it final? No, because it is for conviction. It is only final after the lapse of the 15-day period. So what shall you do if you fail to appear? Remember, you lose the remedies. You lost your good standing before the court. So to reacquire that good standing within 15 days from promulgation, either you surrender and file a motion of leave of court to avail of these remedies. He shall state the reason for his absence at the scheduled promulgation, and if he proves that his absence was for a justifiable cause, he shall be allowed to avail of said remedies within 15 days from notice. So if it is for acquittal, remember, no harm done. In fact, it is immediately final. But the problem is if it is for conviction, because you will lose your right to appeal. And to regain such good standing, you surrender and file a motion for leave to avail of these remedies. The reason is simple. When the accused on bail fails to present himself at the promulgation of a judgment of conviction, he is considered to have lost his standing in court. Without standing in court, the accused cannot invoke the jurisdiction to seek the relief. Hence, the motion for leave to avail of the remedies. So that is your remedy. Modification of judgment. What is it all about? A judgment of conviction may be modified or set aside upon the motion of the accused, before the judgment becomes final, or before appeal is perfected. Remember the 15-day period, you have their remedies that you can avail within the 15-day period. Because after the 15-day period, you have no more remedies to speak of because your judgment of conviction is considered to be final. So prior to the lapse of the 15-day period, you can appeal or file a motion, either new trial or motion for reconsideration. It's up to you. So, if you wish to have the modification of your judgment of conviction, for example, on ground that you discovered a new evidence that, if admitted by the court, will surely change the verdict, that is allowed, but subject to the approval, and a hearing shall be done. So in new trial or reconsideration, it is governed by the next rule. And then on the next rule, you have their appeal. So when will you do that? Within the period before the judgment becomes final. A judgment becomes final after the lapse of the period of perfecting an appeal, or when the sentence has been partially or totally satisfied or served, or when the accused has waived in writing his right to appeal or has applied for probation. So what does the second paragraph mean? As to the paragraph A, judgment is not yet final before the lapse of the 15-day period. But after the lapse of the period of perfecting an appeal, which is the 15-day period that we have been talking about, the judgment shall become final. Now, how about paragraph B? When the sentence has been partially or totally satisfied or served, meaning to say, you have underwent preventive imprisonment. And that preventive imprisonment shall be credited, diba, against your sentence. So, if that is already satisfied, or records would show that you have fully served your sentence because your preventive imprisonment is sufficient to cover the penalty imposed by the court, and usually your preventive imprisonment is actually more than the prescribed or the penalty that can be imposed by the court, then judgment there, the conviction of judgment there is considered to be final right then and there. In fact, you have satisfied or fully served your sentence. Next, when the accused has waived in writing his right to appeal. In other words, you submitted before the court after the promulgation that you waive your right to appeal, that you are not appealing your conviction. With that manifestation of yours, then judgment is considered to be final. And lastly, if you applied for probation, because when you applied for probation, wherein the court, wherein the law likewise required that the same shall be done within a period of perfecting an appeal. So if you applied for probation, then that manifests that you are actually accepting the conviction. Hence, it is considered to be final. Entry of judgment. After a judgment has become final, it shall be entered in accordance with Rule 36. And nothing in this rule shall affect any existing provisions in the laws governing suspension of sentence, probation, or parole. So what, the last screen actually enumerates what are the possible remedies that you can avail of after you had there a judgment of conviction. Before the judgment of conviction becomes final, The convicted accused may avail of certain remedies as follows. Modification of judgment in Rule 20. So we're done with this. So you do that prior to the finality of judgment. Reopening of the proceeding in Rule 119. That would be subject to the discretion / approval of the court depending on the circumstances. Usually the reason is to prevent manifest injustice on how the proceeding was done by the court before. So you just have to move for its reopening. Meaning to say, even if you already formally rested its case, but if it would end up depriving due process or justice that the accused deserves, the court would reconsider and reopen, allow you to present further evidence. Motion for new trial under Rule 121, as well as motion for reconsideration, which will we tackle as well, and then appeal under Rule 122. So those are the salient features under Rule 120 on judgment.